join us this evening. I'm going to monitor the chat box throughout Leanne's lecture, and the format for this evening is it will be a lecture for about 30 minutes or so, and then we'll stop for a Q&A, but feel free to type any messages into the chat, any questions into the chat, or save those questions to ask yourself directly in the Q&A, which will follow Leanne's lecture. So why are we meeting for Social Sciences Week? Well, as I think we'd all agree, social sciences are key to understanding humanity, society, and the institutions which govern our daily lives. And Social Sciences Week is a week-long series of events held across Australia each September, offering insight into the impact of social sciences on our lives. It's an initiative coordinated by the Academy of Social Sciences in Australia. I'll introduce the wonderful Leanne Weber now, who's Professor in Criminology at the Canberra Law School, and we're delighted that she joined us in February of this year. And Leanne's also a Research Associate at the Centre for Criminology, Oxford University. She researches policing and border control using criminological and human rights frameworks. Her many books include the Elgar Handbook of Migration and Global Justice with Claudia Tazreiter, Crime, Justice and Human Rights with Elaine, Fishwick and Marinella Marmo. I think some of the co-authors are here tonight, so welcome. Policing Non-Citizens, sole authored, and Globalization and Borders, Death at the Global Frontier with Sharon Pickering, which was awarded the inaugural Christine M. Alder Book Prize by the ANZ Society of Criminology. Welcome everyone, and take it away, Leanne.
Well, thanks, Alison, for that introduction. And I want to thank everyone, all of you, for delaying your dinner tonight, if that's what you've done, to join us. I'm really grateful. Perhaps some of you are multitasking and buzzing around in the kitchen getting dinner as we speak, and that's perfectly fine. We're not going to stand on ceremony. I want to also thank Alison, Nilima Matai and Katerina Georgievska at UC for supporting and organising this event, and also ANZOC, the ANZ Society of Criminology, for their additional support for the event. I'm coming to you tonight, not from Canberra, but from the beautiful Snowy Mountains, where I'm very privileged to live. And thank you, Alison, for that tip. I was going to say the Narrogoo name for the Snowy Mountains, but I'll refrain from that. I want to acknowledge that this land always was and always will be Narrogoo land, and I want to pay my respects to elders past and present. So I want to start my talk this evening with the most provocative part of my title, The Dangers of Law Without Social Context. It sounds very dramatic. And I'm going to rely entirely on a single anecdote to make that rather weighty point. So fingers crossed it'll hit the mark. Quite a few years ago, I think it would have been around 2008, I was a very junior academic at that stage in Sydney. I wasn't young, but I was still growing into the role. I started academia quite late in life, and I wasn't all that confident in myself, and that's kind of relevant to the story. I heard about a seminar to be given by a renowned penology scholar who was visiting from overseas, and the venue for that talk was a prestigious law school in another Sydney-based university. So I decided to go along, and I eventually found the room. And I was very surprised initially that it was quite a small and intimate seminar room. I'd expected at least a small lecture theatre for, considering how well known this scholar was. So I was a bit taken aback, and I vividly remember peering through a glass panel in the door and inside the room seeing just a handful of people seated around a table. So it was quite an intimidating scene for me at that stage of my career. And I almost turned around and left. But I took a deep breath and I walked right in. So the renowned scholar, as I'm going to keep calling him just for a bit of dramatic tension, started to explain that he was going to present the ideas of a German legal theorist whose name I didn't pick up, I didn't recognise it, and so I didn't really even remember it at the time. But as he spoke, I became more and more alarmed at what sounded like very disturbing ideas for me that this renowned scholar was putting forward. I knew they weren't his ideas, but he was just continuing to speak without any critique. So it was a while ago, but the core idea I remember was that some categories of people should be treated quite separately under law using exceptional measures. And one example that stuck in my mind were habitual offenders, so-called, who, according to this worldview, were showing that they rejected societal values by their continuing offending. And so the argument was they couldn't be rehabilitated through the usual operation of law and criminal justice. Something different, something exceptional was needed. So to calm myself down, I was getting a bit agitated by this stage. I told myself, this is exposition, you know, it's just the renowned scholar is going to launch into critique soon, but that never happened. And he finished speaking and opened up the discussion to the floor. And what followed was a very spirited exchange between legal academics that was entirely about doctrinal matters. I tried to follow it. I wasn't any, you know, stranger to philosophical discussion, but there was lots of unfamiliar terminology in there. And on top of that, my brain was being flooded by stress hormones at that stage, and so that didn't help the concentration. And I was becoming really distressed that these pernicious ideas were really not going, they were going unchallenged. I started to wonder if I was maybe misreading the room and everyone else was just as alarmed as me, but just playing by a different set of rules perhaps. And then I distinctly remember a young woman prefacing her comments with, I can see how we might need special rules for incorrigible reoffenders, but the point that bothers me, and then going on and pointing out a technical flaw in the German legal scholar's argument. So although I was absolutely shaking with nerves by this time, that was the point that galvanized me into action. I thought, we have to put a different perspective here. So I took my turn and I explained, I almost apologized actually, that I was a criminologist, not a lawyer, that we focused on how laws impacted society, and I wasn't really qualified to contribute to their doctrinal debate, but that I needed to say that I thought these ideas were divisive and very, very dangerous. We were already seeing them play out, for example, in counter-terror legislation after the 9/11 events. I remember looking to the renowned scholar as I was speaking for support, but he remained absolutely inscrutable. So I made a final point, I think, about how we'd seen similar developments historically that had had devastating effects. And of course, I was alluding there to the Holocaust and the slow build-up in Nazi Germany. But I was afraid to mention that outright, you know, for fear of instantly losing credibility by making that comparison. So after I finished, there was a short silence, still no reaction from the renowned scholar. And to my intense discomfort, the doctrinal discussion just resumed as if my intervention had been just an embarrassing sort of interruption. So as the session came to a merciful end, I was planning a very quick escape, as you might imagine. But on my way to the door, the renowned scholar, as I keep calling him, intercepted me very amicably, just for a chat, still keeping his cards very close to his chest, but signalling, I thought at the time, that he was very relieved that someone had spoken up about the wider implications of the ideas that he'd put forward. So life moved on. You know, I didn't lose a lot of sleep after that, thinking about that, but there was a sequel to these events that came, you know, quite a few years later, when I spotted this article, which would come up if that was working. There we go. When I spotted this article that was published, and it's probably not a coincidence, just prior to that fateful seminar that I just talked about. So although it was published around about the same time, I didn't see it for quite a long time later. So I was initially attracted to the reference to the border in the title. That was aligned with my research field at the time and still, but it turned out the article wasn't about geographical borders at all. It was by Susan Krassmann, who's also a German legal scholar, and she was mounting an explicit critique of the writings of another German scholar, whose ideas, as I read the article, began to look very familiar. I realised this was the body of legal thinking I'd heard all those years ago in that seminar at the prestigious law school that I just recounted to you. I can now reveal that the German legal scholar she was critiquing in this article was Gunther Jacobs, and I think possibly many of you guessed that from what I was saying earlier. And his ideas about Feindstrafrecht, or enemy penology, as it was translated. I can also reveal that the renowned penology scholar at that seminar was Anthony Duff. And I'm sure that many of you would agree that he is very unlikely to have endorsed these kinds of ideas. But just to give you fill out a bit more detail about it, the border that Crossman is referring to in her article is a theorised border between the liberal rule of law and the state of exception, between criminal justice and security, and in some ways between law and politics. And transgressing these borders, Crossman argued, as she believes Jacobs has done, transforms the democratic state to the preventive state, where certain groups are treated as enemies of the people and targeted for special measures, often punished preemptively for who they are and what they might do, not for what they have done. So criminologists listening will recognise these ideas really as the so-called new penology, based on pre-crime and preemption of risk. In case you think I may have been overreacting at the seminar, here's a direct quote from Jacobs' writings as translated by Crossman. And she says, quoting Jacobs, "Enemies are currently non-persons. Enemy penology is thus warfare, and it's necessary because of the impossibility of a comprehensive legal regulation. Moreover, enemies are not so much to be punished in the sense we usually understand it, but in Crossman's translation, and I quote, combated, excluded, even extinguished." This is alarming terminology. So this encouraged me to read more about Jacobs' work. All of it was critical. All the articles I read were critical of Jacobs' work. They were all in law journals, so I'm not in the least suggesting that only social scientists can look at law in social context. Not at all. Some of the articles were quite doctrinal, but one author, I remember, described Jacobs' thesis openly as Nazi law. And this wasn't just as a casual label, but having established through historical legal research presented in the article, the trajectory in Nazi Germany that had transformed German law, making possible what Hannah Arendt famously called the legal crimes of the Holocaust. So looking back, perhaps I could have been braver at the seminar and made that point more explicitly. But further down the track now, I think we've all seen some of these ideas play out. And it seems like the idea of enemies is easily evoked in public discourse, at least in discourse, if not in law. And so this is a notorious headline that some of you might have seen that demonised two very young women of colour who transgressed COVID rules to sneak over the Queensland border some months back. And it shows really how easily our definition of enemies becomes racialised. Jacobs in his work refers, I believe, only to citizens, but I've ended up applying these ideas in my work, critically, of course, not condoning them, to describe the treatment of certain categories of non-citizen, for example, asylum seekers, who've long been demonised as a threat to national security, which makes them very vulnerable to classification as social enemies. And so one example is this recent chapter written with my colleague and sometime HDR student, Beck Powell, where we apply enemy penology at the nexus of the criminal justice and immigration control systems as it impacts on several categories of non-citizens. So I would say the social impact of enemy penology is very real. We are seeing it. And so my excuse me, my outing to that seminar in the prestigious law school, which I still will keep that nameless, although it was somewhat unsettling at the time, it turned out to be really productive after all. So now I want to move on to the more warm and fuzzy part of my title, how good things happen when law and social sciences get together. And I really endorse that wholeheartedly and embrace that in my own work. So when I made the move to the Canberra Law School in February this year, I found myself out of my comfort zone, I'll be honest, as the only social scientist in a school of lawyers. And I realise as I'm saying school of lawyers, it sounds a bit like school of sharks, but that's not my intention. Despite having really lovely and welcoming colleagues, I still find myself at times pondering where I fit in, really. And that's the basis for this talk, with Social Science Week really providing a perfect opportunity to give these ideas an airing. So being a social scientist, of course, what I did to try and work out these thoughts was to devise a diagram. So here it is. There's no earth-shattering revelations for any of you in there. The diagram runs from the most doctrinal approaches to law on the left, with increasing recognition of social context as you move to the right, until you reach branches of social science where, you know, relations between people and social institutions are the primary focus, and law all but disappears. Although I suspect law is always lurking somewhere there in the background. Of course, the arrows could go in the different direction, but being not the most technically proficient social scientist, I couldn't work out how to do that. All I want to say about this diagram is when it comes to defining and conducting research, although there's lots of productive space for lawyers and social scientists to meet, you know, in the middle of this diagram, it really matters where you start along the spectrum. It really changes the way you approach your research. And this was brought home to me the very first day that I was at the Canberra Law School, and I was at a gathering to meet new colleagues. And the very first question I was asked was about the new discovery project that would now be coming with me and be hosted at the school. And I replied to that question that the study was about interactions between criminal justice and migration control systems in relation to deportation following criminal offending. And the second question that followed immediately was, what are the leading cases? And I remember going, yikes, you know, I don't know. It was a totally valid question, but it caught me unprepared. And so I think I said something about the project being more about institutional practice. But it was a really good question to be asked, because it started me thinking about these different starting points and framings for research and where those different starting points might take you. So in that new discovery project, we visualised the criminal deportation process as a crimigration assemblage. So crimigration combining, you know, criminal justice and migration control, in order to understand the interactions between those two systems. And I'm just going to show you a really horrendous diagram, which is our conceptualisation of the project. So our approach is highly process orientated. We've identified multiple nodes in the assemblage where we suspect information or resources might be exchanged between agencies, and we might find a lot more as we go along. But what I want to say really about this is that the idea for the project started from human concern about the impact of this type of deportation, how it breaks up families, how people can be sent to a place they barely know after long periods of residence in Australia. And I think I can speak for the whole team by saying that we wouldn't have embarked on this project for any other reason. We all shared those concerns. So the starting point was clearly very much to the far right end of the diagram on the previous slide, where humanity and social institutions are the main focus. As our project progresses, we'll no doubt find our way to something resembling case law. For example, we're going to be looking at administrative appeals tribunal decisions. But even there, our interest is to learn more about the interaction of agencies and between agencies, and the implications for those who are threatened with deportation, not so much the nature of the legal decision making. So it would be a very different project if we'd started at the left-hand side of the diagram, according to my previous slide. So the last thing I want to say, although I'll take a fair bit of time to say it, is that there are positive aspects of these differences in starting points and framings for research, because pretty obviously lawyers and social scientists can pool their different skills and perspectives to work together in what is often some pretty exciting ways. So I made a list of a few ways this can happen. Again, it's based on my own experience, and I'd be really pleased if you could add your own insights and experiences about these kinds of connections in the chat, if anything comes into your mind. So the first 2 points are quite self-explanatory. Firstly, some academics embody the benefits of both legal knowledge and social science skills and perspectives by studying across both these fields. And these people, in my experience, are absolutely awesome scholars. Obviously, social scientists can team up with academic lawyers to pursue empirical research or major writing projects. That's a pretty obvious point. For the crimigration assemblage project I just mentioned, I'm working with what I consider to be my dream team of Faith Gordon, Marinella, Marmo, Alison Gerard, all of whom have legal and social science qualifications. So they're the real deal. And I have to say to you, though, that I rely very heavily on their lawyer sensibilities to pull me back in line if I start getting a bit fast and loose with legal matters. When I look back over the publications, my own publications from the last few years, I was actually quite surprised to see that almost to a single one, virtually all of my collaborators in that writing had legal qualifications. I hadn't really realised I was veering so much towards the dark side over the last few years. So I want to give a shout out here to Jude McCulloch, Louise Bunkuo, Vicky Centers, and my longtime collaborator and multi-talented lawyer come social scientist, Elaine Fishwick. In addition to close collaborations, sometimes lawyers and social scientists work together more loosely. This is what I refer to as networking. So we've recently started an ANZ thematic group on criminological and border control that includes many legal academics, some of whom don't identify strongly as criminologists. And I want to illustrate with yet another anecdote, a shorter one this time, how fruitful it can be just to be aware of each other's work across disciplinary divides. So a little while back, I became interested in the code of conduct that asylum seekers living in the community are required to sign in order to obtain bridging visas. So two young legal academics, Anthea Vogel and Elise Methven, were doing some great work on this, and I am reading their accounts, including one unpublished account, which they were kind enough to send me, really helped me get my head around how this very dubious document operated in law. I somehow found out that Anthea and Elise had obtained some official data about code of conduct breaches via an FOI application. And I have to say, just another observation is that FOI seems to be the research tool of choice, freedom of information, I should say, for anyone wondering, by lawyers, and yet it seems to me pretty underused by social scientists. Perhaps some of us are just put off by the fact that there's a legal framework, but hopefully we'll start using it more. So Elise and Anthea generously provided their raw data to me that they received from the FOI, and I could see, frankly, that it was a mess, and that's no reflection on them whatsoever. No interpretive notes were provided, and I don't know what others think, but I'm starting to wonder whether it's part of a deliberate tactic to provide data that no one can interpret. Anyway, we had to work together to pool our expertise to really get anywhere with it. And including some help from Meg Randolph, who's been an HDR student and long-time research assistant with me. She helped to transfer the raw data into SPSS so we could readily crunch it around and generate some simple tables. And we produced a short report for that, which we posted on the Border Crossing Observatory. So even with these flash tables, we were still struggling to interpret how the code of conduct was actually being used, in particular whether bridging visas were actually being revoked for breaches of the code, which is some pretty dubious and trivial, matters, whether they were actually leading to the very serious outcome of having your visa cancelled, or whether in fact most cancellations were due to a breach of the visa conditions or a criminal offence. Anthea and Elise tried to work this out from the FOI data itself, based on what sections of the Migration Act were being invoked. They were a lot better at figuring that out than me, but we were still unsure at the end of the day because of the inadequacies in the data. So suddenly I remembered having interviewed the immigration official in charge of this scheme for my own research, where I seem to remember this point had come up. So I went back and checked the transcript and confirmed that he had said he only remembered 1 or 2 cases since the code was introduced where breaches of the code itself had been used to cancel a bridging visa. So between us using the legal approach of FOI and the social science approach of speaking with people, we felt fairly certain we could figure out what was going on. So it was a very long-winded but quite simple explanation there of just how useful it can be just to know of each other's work and combine your skills and ways of looking at things. So the last 2 examples I'm going to talk about concern social scientists working with legal practitioners, which has been a really interesting and exciting part of my research career. So legal practitioners are out there doing all sorts of amazing things in the community. And recently I completed some research in Melbourne on the racialised policing of young people from Pacifica and South Sudanese communities. And the main facilitators of access to the young people in that case were actually youth and community workers, not lawyers, and they're also amazing people to work with. But after that work was done, the group that did the most to use the research findings and increase awareness about the study was the Flemington and Kensington Legal Centre, who have a long history of legal advocacy for young people of colour, especially through their Police Accountability Project. So we had ambitious plans to disseminate the findings and discuss them with affected communities, but they were scuppered by COVID. But I was still very grateful to Flemken, as they're affectionately known, for their acumen in providing really quality media contacts to try to get some impact. So that's one really positive example for me of working together with community lawyers. A second example goes way, way back, right to the 1990s, to the first ever major empirical research that I did before I was even a fully fledged academic. And I was living in the UK. And in that study, I interviewed border officials at UK ports of entry about their discretionary decisions to detain asylum seekers. So this project arose out of activism and the knowledge about the system that I built up from hanging around with incredibly dedicated immigration lawyers who work tirelessly to get people released from detention and to win their asylum claims in a very different system from here. When I obtained charitable funding to do these interviews, and incredibly gained approval from the Home Office to interview frontline officials, this network of lawyers were supportive, of course, but universally, down to the last one of them, they were pessimistic about obtaining anything useful. It was really quite disheartening. They all said I'd just be told the party line. You know, if I interviewed immigration officers, they just tell me what they thought I was supposed to hear. Detention was being used as the last resort, rada, 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 when all of us knew that it wasn't. And I'd just be wasting my time. Well, as it turned out, nothing could have been further from the truth. This is one time when I'll say the lawyers were wrong. And what I found was an incredible diversity in views and reported practices from these immigration officials, these border officials, ranging from those who were on a mission to keep asylum seekers out of the country to people who seemed to have self-selected into my study. And I didn't mind it being, you know, perhaps a bit of a breach in optimum methodology there. Obviously, people were self-selecting into the study in order to expose practices that they believed were unlawful or that they disapproved of, including every social researcher's dream, interviewing an experienced immigration officer who was retiring the very next day. That was absolute gold. So, in fact, the diversity was so marked that individual differences became the focus of some of my analyses, and it wasn't the only thing, but I did a lot of work on that. And I used the idea of obedience to authority from social psychology to show that not all border officials towed the party line, which is what the lawyers thought that I would find. So time doesn't really permit for me to explain this typology, but I hope just having a bit of a look, if you've got the time, at the different ways each of these individuals talks about their work shows you a very marked contrast. And the way they differ, I would argue, is in their orientations towards institutional authority. So I tentatively concluded on the basis of this self-reported practice, I didn't have any quantitative data to back this up, but that role-governed officers would be the ones who are very attached to that, you know, having a mission to protect the UK borders. They'd be the most likely to detain. But rule-governed officers would go along with whatever they saw as being, you know, the common practice in their work location. And it's worth noting that doesn't always mean that they would follow the law. They would follow whatever was the customary practice in the place that they were working. While value-driven individuals, they stood out so clearly, were prepared to go against the grain if necessary, to keep detention to a minimum because of their personal convictions. So this experience taught me about professional positionality. I'm quite pleased with that term. I've just made that up in preparing this talk. Professional positionality. That dedicated lawyers were so pessimistic about the value of speaking with decision makers not because they were wrong, but because their own experience was that they encountered immigration officers in adversarial situations where officials were loath to disclose any information that might affect a particular asylum claim or bail application. While I, on the other hand, as a mere social researcher, appeared to be completely harmless and presented no threat. Well, actually, that turned out not to be really true, but that's, I'm sure it was how I was perceived, and people opened up to me amazingly. So I later presented to Immigration Lawyers Association, and one lawyer came up to me afterwards and said how he now understood how decisions were made so that he could fight for his clients' freedom more effectively. I don't think I've ever had such impact since, so I peaked very, very early, never to be repeated. And the reports that I produced from that research were even discussed in the House of Lords. And I mentioned that not to brag, because it was nothing to do with me and everything to do with those very well-connected lawyers. So that gave me a taste really of how social research could translate into legal practice if you worked closely with practicing lawyers. So back to the list and the final point, you'll be glad to hear it's the final point. It concerns how valuable lawyers working in the community can be as actual informants in social research. So I did some work a few years back about how welfare systems are used as a form of border policing in relation to asylum seekers. For example, by creating webs of surveillance and encouraging the withdrawal of asylum claims by denying applicants the means of survival, basically starving them out, to put it crudely. And so I began by speaking with welfare providers in health, education, housing sectors. And then I decided that I needed to speak with lawyers who were assisting asylum seekers with their applications, just mainly to clarify, their legal entitlements, to make sure I got that right. But what I found out from these incredibly dedicated community-based lawyers was a lot more than just that. Again, there's a lot on there. I'm just going to leave you to absorb some of it if you can in a few seconds. I won't have time to read every word. But the point I'd like to make is just this, that these are not dry statements about law and legal process. These advocates were clearly involved in many areas of their clients' lives and had a better overview of what was going on systemically than most of the service providers I spoke with. And that's no criticism of them at all. Again, it's a matter of professional positionality. And this reminds me of something one of my new colleagues at Canberra Law School has said to me. So her name is Doris Bozen, and she's come into academia very experienced in alternative dispute resolution mechanisms and has brought that knowledge with her. And she said something to me once along these lines: we teach our students about the law, but what many of them will end up doing most of the time is solving problems in people's lives. So even practicing law in the real world, it seems, turns out to be more than just the law. So that's basically all I've planned to say this evening. So thanks for hanging in, those of you who have got through to the end of the lecture part anyway. I know many of you will want to be heading off for dinner now, but I'd love to hear your thoughts and experiences if you have time to stay around to talk for a bit longer. I've realised as I've gone over the content of what I presented this evening that's entirely research focused, and that's not surprising, that relates to my own experience, but that this is a topic really, the interactions and synergies, to use that word, between law and social science is a topic that would be fascinating to explore in relation to cross-disciplinary teaching as well. So Alison, perhaps that's the next event can be a panel event where we can perhaps talk about that issue. And on that note, I'll hand back to Alison.
Thank you, Leanne. On behalf of all of us, can we give you a wonderful round of applause for your, honest presentation and account of your research over a number of decades and the impact it's had and the synergies with people from other disciplines. It was very wonderful and always very funny and human, which is what we love about you presenting. So look, you've kicked off with a question about the interdisciplinary nature of teaching, which is a good place to start. So let's imagine that this is the panel. We've got a variety of different perspectives and people here from different backgrounds, etc. So we really do want to hear from others. Heber is here. Welcome, Heber. And Heber's put a comment in the chat about some crossovers and synergies with her work with Syrian refugees. And I think what you were talking spoke a lot about the context that the Heber is familiar with. So Heber, feel free to share your insights, but other people on the in the seminar, feel free also to either type a question in the chat or to take your mic off and ask a question directly. I'm going to warm everybody. Heber, I know you've just turned your camera on, so I'm going to anticipate that there might be a question or a comment coming from you.
Hi, thank you so much, Leanne. That was really very, very interesting. And I'm really excited that you're actually working in this area and that you're actually in our faculty. So welcome. We haven't met since you've joined us. So I'm really excited to be hearing about this work taking place in our school, in our faculty. The reason why I was really excited about your work, not because it's actually interesting by itself, but also because I have been working with Syrian refugees for a while, and I myself am from the Middle East. And the security paradigm, of course, permeates the refugee experience and even the citizen experience in the Middle East more generally. And what happens is that people have a particular experience of the security paradigm, even in their own country. So Syria, you know, the walls have ears. And so they grew up in a particular context. And then as refugees, but then again, as resettled in countries like Australia. And what happens, and I was looking at this, I was doing the research from a women, peace and security perspective, which is a UN resolution. And one of the pillars is participation. And I was really, I'm still currently also theorizing, what does participation mean politically for women in the diaspora? And so when I interviewed women here in Australia in their own context, you'll see that this security and it permeates their lives on so many different levels. And so whilst, you know, criminal actions by them or their husbands or their family members here in Australia as a result of gaps in the welfare system that's provided to them can lead them, you know, into trouble. But aside from that, it's also the overall environment that prevents them from continuing to participate in peace processes and understanding their identity, their political subjectivity in Australia. And so that, you know, so I just got excited. I just wanted to tell you about my excitement. That's all I wanted to.
Thank you, Heber, for sharing all that. That sounds like extremely important work that you're doing. And I guess all I'd say about that, I won't say a lot, but it sounds like you're working with primarily with refugees who came to Australia in an organised fashion, in a
Yes.
program from Syria. And so because my field is border control more than just, you know, asylum seeking itself as a topic, I've, I guess, focused primarily on those who continue to be subject to border control. So people
Leanne, this is what I wanted to just point out. I guess the final comment is the border follows you, the metaphorical border. So even if you came here on a vulnerable women's visa or a humanitarian visa, and you didn't come here by boat, the border follows you anyway. And I think that's kind of another metaphor for the border. That might be useful.
Yeah, that's really important to know. And I guess that all I was going to say was, if things are as bad as what you described for people who arrive in a situation where they are immediately able to be settled, in inverted commas, imagine how bad it is for people who are constantly faced with the chance of their visa being revoked and them being redetained and possibly sent back. Yeah. So insecurity definitely prevails.
So much.
Leanne, some of your earlier work characterised the different topology of borders. How do you think that shifted people's, I guess, strictly legal notion of borders as a geographic boundary to something that does follow you?
It's funny you should ask that, Alison. We haven't actually cooked this up, everybody, but I just finished today a guest lecture I'll be giving tomorrow in an international law, which is a bit terrifying since I'm not a lawyer. This is the sort of thing I face all the time, having to pretend I'm a lawyer. It's an international law course, and I'll be talking about Australian border control. And the first few steps I take with students is to get them to question what is a border and tell me what they think a border is. I don't know what they're going to say, but I imagine it'll be mainly about, you know, a line, a boundary that they can see on a map. And then, of course, we're going to unsettle that idea and talk about borders being a geographical construct, a legal construct, and, of course, a very politicised construct. I won't give the whole lecture. I was just going to stop there.
That was a wonderful taste. Faith has just put a comment into the box. Faith, do you want to speak to that? Faith, of course, is also on the project team with Leanne on the Crimmigration ARC project. Do you want to speak to that, Faith?
Thank you. Yeah, I've also just typed really quickly there a question, so I'll put it in too. Yeah, it was just a point about how I've used Leanne's research in my teaching. So I've just moved to ANU College of Law and convening a priestly 11 on criminal law and procedure. And I use Leanne's work on policing, belonging in young people to contextualise a lot of the procedures, to talk to students about the impact on the ground. And this was something that the students were extremely receptive to. And in the feedback about the unit, they talked about the importance of considering the impact. So Leanne's work was just so great in relation to that. I'd be really keen to hear more about your work in human rights, Leanne, and the kind of the, I know that with Elaine and Marinella and others, you have been doing a lot of work in relation to human rights and criminal justice. And I guess, you know, human rights, you know, I would say traditionally sits in kind of probably the law a bit on your diagram. So I'm really interested to hear about how you got into doing that work. And yeah, I'd love to hear a bit more about that, if that's okay.
Okay, well, thanks, Faith. And I noticed that Elaine's just popped up a question there about teaching criminology in a law school. So maybe if and when Elaine comes up, she can also talk about your question, Faith. I can sort of shove it onto her as well, because Elaine Fishwick, of course, is one of the people who's worked with me on some of this work, trying to translate human rights ideas out of law and into a format that criminologists can relate to. So yeah, we've published a couple of books on that. One was an attempt to do just what I just described, just look critically at human rights too, not just accept them as, you know, simply a statement of fact because there are treaties about them. You know, we look at the philosophy and the politics of them and how human rights can be, you know, really misused and misapplied to achieve all sorts of nefarious ends. I think we've all seen that happening over the last 10 years or so. So it's a very contextualised look at human rights. And we produced a handbook with Routledge and continued, and also a chapter recently in a student textbook. So we're trying to get the message out there. My main thinking about it was that human rights was often just used as a bit of a slogan if it was mentioned at all in criminology, and that's not a good thing, just to think, oh, it's a good thing to say this is about human rights in some broad sense. We wanted just to provide a platform for criminologists to perhaps get a bit more depth in their understanding of the, you know, positives and negatives about framing issues in human rights terms. Elaine, do you want to say anything more about that?
Well, it brings to the things I was going to say together, so well done, and we didn't miss that either. I think from my point of view, there's sort of work on human rights that I did with Leanne and Marinella. I mean, mine came from advocacy, sort of on the ground advocacy, working with young people, and I was using human rights framework as a way to try and improve justice outcomes and to make governments pay attention to the injustices that young people have faced, as, you know, especially First Nations young people in this country, and to try and effect some kind of change. And I think, to be honest, we've probably been highly unsuccessful in doing that in Australia, in using human rights as a tool of advocacy. But I think what it does is bring me back to the point I wanted to make about teaching in a law school and teaching criminology in a law school. I have got a joint arts law degree, and I've done lots of work in the community legal sector, so I'm sort of done paralegal work as well as other work. But one of the things I found really, really interesting, and I think it comes back to that framework, that slide you had at the beginning, was that for me, quite a lot of the legal approach that I find when I'm teaching social science in a law school is this lack of understanding that law is only one branch of policy. And I find that students found that very difficult to think outside of how you achieve justice outside of a legal framework. And so I try and use Carol Batch's work is what is a problem represented to be? What is the problem? And to challenge that kind of legal thinking always, and to see that criminal law is only one small branch of policy. And I really enjoy doing it because I think it allows students to, and there's a lot of students who suddenly go, ping, oh, okay. And it allows them to bring a broader social justice framework to that understanding. And I think that is it provides opportunities for law students who might be a bit sort of feeling a bit narrowed by the way that the law approaches problems and policy issues and addressing things like how poverty affects, sort of justice. And so that was just my observation on that.
You're doing a great job there, Elaine. And I think, Alison, we'll have to do that final little sting that we've discussed at the end, because I think the quote that I would like to leave everyone with will really speak to a few things Elaine's just said.
Wonderful, and we're just building the tension again. This is wonderful dramatic effect here in this seminar. Thanks, Elaine. You certainly, what you had to say certainly resonated with my experience of law school and the, curiosity that something was missing. I was missing part of the puzzle. I'm going to go to Christy next and then Lorana. Christy.
Thank you, Leanne. So I was intrigued by your discussion of the kind of the mixed methodology that you brought together in relation to the sort of the use of the behavioural orders for the bridging evaders. I found it really interesting when I did my PhD in a law school that my research was primarily qualitative and it was primarily interview based. And one of my supervisors, when I used the interview data in my thesis, was like, "Oh, but you can't rely on this as evidence, can you?" And so there was this real kind of disjunction between these different methodologies and understanding them as being valid sources of evidence. And I wonder if that rigidity comes from both perspectives, or if lawyers are particularly inclined towards that kind of doctrinal understanding of what is real evidence.
I think we have the equivalent in social science, and I didn't want to start any internecine wars here, and so I've just talked about social science as if it's all critical and all fantastic, but you've made a really fantastic point there. And it just so happens, I don't know if quoting Twitter in an academic forum is really the best thing to do, but a very senior academic who shall remain nameless just tweeted quite recently something about his annoyed with people using lived experience rather than evidence. And I felt, that I had an obligation to respond and sort of say, well, lived experience, which is not my favourite term in the world either, but that qualitative rendering of people's lives and experiences is absolute evidence. And I think I said it depends entirely what questions you ask. But clearly these types of questions for which people's experiences and accounts of their experiences are the answer, are the evidence, have not been part of your lived experience or something, just trying to turn it a bit back on him. So I think the equivalent of the narrow doctrinal approach within social science can be a kind of positivist. I'm not against quantifying things, but if you reduce everything to something that is just able to be quantified, you lose so much of the human aspect of it. And so that kind of narrow approach is not one that appeals to me. And I much prefer being open to the question, being led by the question, being led by the real world phenomenon that you're trying to find out about, and bring to bear whatever sort of evidence will really help you understand it. So I think understanding issues rather than proving something is more important to me. Thank you, Christy.
Thanks, Leanne. And now to the former head of the Canberra Law School, adjunct professor with us and professor at ANU, Lorana Bartels and Kat. You have the floor.
And my cat. Let me work out how to get my hand down at the same time. Thank you. I have kind of comments that sort of build on what Leanne and Elaine in particular have said, that really echo the need for understanding and cross-pollination or fertilization. Firstly, a comment from a former boss of mine at the Australian Institute of Criminology who said, oh, well, legal research is just a lit review. And I was like, my 4 law qualifications and I would suggest otherwise. But then interestingly, when I was at UC and teaching criminal law as a priestly unit and trying to provide that broader social, political, historical context for how we have the laws we have and why, I got a glorious piece of anonymous student feedback saying something to the effect of, the course is criminal law, not criminology. This lecturer clearly doesn't know. All I want to know is how to get my guy off or send him away. Get someone who knows how to teach this course, which was fantastic. And, you know, really highlighted for me the importance of teaching, not just the context, but explaining to students why you're teaching the context. And of course, if you're teaching law, you need to teach the elements and statutory analysis and all of those things, but explain why all those other things matter. So you don't have students and graduates who say those sorts of things. And so they do understand why you're giving them statistics about overrepresentation or policing practices or any of those sorts of things. Yeah, so you don't have these atomized perspectives and that rigidity, but break down those silos. And then thirdly, and finally, if you'll indulge me, now I'm at ANU in a criminology department, and just earlier this year taught a course on the courts to criminology students. And that was actually probably my most interesting teaching experience, because I had to kind of unlearn 25 years of legal thinking and teach for non-lawyers what do they need to know about the courts, and you know, things that I had sort of not that I thought about them uncritically, but had to learn how to teach them in a non-lawyer way, and I learned a lot about the legal system and kind of revisited and re-examined my thinking about the legal system through that. So I think we can constantly reevaluate our disciplinary biases and need to have these conversations constantly, iteratively, with our colleagues, with our students, to unpack where we're coming from in our starting position and those arrows going in multiple directions, Leanne. So thank you.
Oh, thanks for that, Lorana. And I would have to say, your spirit is still lurking in the hallways at the Canberra Law School. I'm sorry that we didn't cross paths, but you know, you've left a big mark there, that's for sure. And thanks for that story. Commiserations about your student feedback. I can maybe top that one. I'm not sure.
I did also say I think it was possibly a man, because this feedback started with Lorana is a man-hating diva and should be fired immediately.
Oh no, I was going to say
feedback ever.
I was going to say I could trump yours, but no, that probably beats mine. But I can remember a piece of student feedback my very first semester I ever taught, so it was terrifying, of course. And I was teaching on a policing course in Sydney, and you know, students who actually were planning to become police officers. And one of them just said very succinctly, "Too much stuff from books."
It's definitely one of these ones to weigh up that competition there. Folks, thank you for your comments and contributions this evening. It's been a really engaging discussion, and something I think everyone has looked forward to in these dark times. Leanne, this is the drum roll moment when you do have the final words of wisdom for the forum tonight. Can I throw to you in anticipation of the final bits to follow?
Yeah, well, I want to leave everyone with a provocative quote, and it's from an American novelist called William Gaddis. I don't know if you know about him. And he has written somewhere, justice, you get justice in the next world. In this one, you have the law. I thought you'd like that, yeah. Elaine. my take on that is that, novelists can get away with being, wittily pessimistic like that. But for those of us who hope there might be a chance of occasionally achieving something that vaguely resembles justice in this world, if we're really trying to work towards that, and you can see I'm not aiming too high there, I really feel that combining the insights and skills of both lawyers and social scientists is absolutely essential. So that's my final word of wisdom. Thank you, everyone.
Thank you again, everyone, for coming. It's been will turn on their cameras and be able to participate. Clearly, the bandwidth gods were with us, and so were the puppy dogs and the children in place at your home. Thank you very much, Leanne. Evening. There's a comment in the chat. Thank you about the recording. We will have the recording available both at the context and with ANZSOC as well. But thanks for all for making your time available. Take care, and we look forward to continuing this discussion in other ways. Thanks, Leanne.
Thank you, everyone.
Thank you. Thank you.